Good morning, guys. This morning I've got discussion aid for you. Now we're discussing when siblings become caretakers for their parents legally. So I'm going to go through the legal steps you need to do to become responsible for your parents. Okay, here we go. If you become the primary caregiver, secure written authority, durable financial power of attorney, and a healthcare proxy. Use a formal caregiver agreement for pay reimbursement and get professional help for Medicaid planning. These steps help for Medicaid planning. These steps help prevent costly guardianship, protect you from fiduciary liability, and preserve benefits. Capacity. Are you are your parents currently competent to sign documents? Money flow. Will you be paid, reimbursed, or simply covering expenses? Just a second. Family dynamics. Do do siblings agree on roles and record keeping? Decision points. If your parents are competent, prioritize POA and advance directives now. If not, expect court guardianship, legal essentials. Durable financial power of attorney grants authority to pay bills, manage accounts, and handle legal/financial matters. Must be signed while the parent is competent. Healthcare proxy and advanced directives. Names who makes medical decisions and and records and records treatments wishes records treatment wishes. Caregiver agreement, a written contract that documents services, hours, and reasonable pay. It convert it converts payments into earned income and helps avoid claims of improper transfers. Guardianship conservatorship. Court ordered when no valid POA exists. It is public, slow, and costly. Avoid by planning early. Medicaid look back and asset transfers. Transfers before applying for Medicaid can trigger penalties that delayed eligibility. Consult an elder law attorney before moving assets. Practical checklist for the next 30 days. Get copies of any wills, POAs, and advance directives. Confirm dates and witnesses. If competent, sign durable financial power of attorney and healthcare proxies immediately. Create a caregiver agreement. If you'll be paid or reimbursed, set a reasonable hourly rate. Keep meticulous records, receipts, bank statements, mileage, and a care log. Talk to an elder attorney and CPA about Medicaid timing, taxes, and fiduciary duties. And when to get help now. Hire an elder law attorney for Medicaid and guardianship risks. Get a CPA if you'll manage significant assets or be paid. Short answer, yes, but only in narrow circumstances. You generally cannot sue a sibling simply for not helping. Successful claims usually require a legal duty, uh, file responsibility statute, fiduciary role. Contact or prove contact or proven neglect, abuse, and clear evidence of harm or financial loss. Quick guide when a lawsuit is possible. Filial responsibility laws exist in some states and can require adult children to support indigenous parents. But these laws are rarely used by private siblings and are usually enforced by nursing homes or government agencies. Fiduciary breach. If a sibling is a court appointed guardian, conservator, or holds a valid power of attorney and mismanages funds or neglects duties, you can sue for breach of fiduciary duty. Contact or Contract or written agreement. A signed caregiver agreement or family contract that's broken can be reinforced in court. Elder abuse and neglect. Proven physical neglect or abuse can trigger civil claims and criminal reporting. Evidence and protective orders strengthen a case. Practical steps before suing. Document everything: care logs, bills you paid, communications, medical records, and bank statements. Demand and mandate. Send a written demand and try mediation. Courts favor attempts to resolve family disputes first. Check state law. Confirm whether your state has a filial responsibility statutes and how they are reinforced, how they are enforced. Consider alternative remedies. Petition for guardianship, conservatorship. Seek removal of a negligent fiduciary or ask a nursing home / state agency to pursue reimbursement. Risks, trade-offs, and when to hire counsel. Family fallout and high legal costs often outweigh recoverable damages. Litigation can be slow and public. Hire an elder law attorney if you have a fiduciary claim, complex finances, or need guardianship. A lawyer can evaluate evidence and local statutes. Short answer: yes, but only narrow, legally recognized situations. If you generally cannot sue a sibling merely for not helping. Successful claims require a legal duty, a final filial responsibility statute, fiduciary role, contact or contractor proven neglect abuse, plus clear evidence of harm or loss. Quick guide. Key considerations, clarifying questions, decision points. Key considerations: legal duty, evidence of harm, parents' financial status, whether a sibling holds a fiduciary role, POA/guardian, and state law. Some states have fellow statutes. Clarifying questions to answer now. Is a sibling a court-appointed guardian or named agent under a POA? Is there a written caregiver agreement? Are parents indigent or on Medicaid? Decision points. If a sibling is a fiduciary, pursue accounting and slash removal. If no legal duty exists, pursue mitigation. Or guardianship petitions. Rather than a straight negligence lawsuit. What evidence matters most? Financial records showing diverted funds, missed bills, or unpaid, unexplained transfers. Written instruments, POA, guardianship orders, caregiver agreements, or recent wills, trust changes, medical records, and witness statements proving neglect or harm. Practical steps before filing a suit. Document everything: care logs, receipts, texts, emails, bank statements. Send a written demand and offer mediation. Courts expect attempts to resolve family disputes first. If a fiduciary is involved, petition the probate court for an accounting or removal. Check state filial laws. Pennsylvania enforces filial support aggressively. Outcomes vary by state. Risks, trade-offs, and when to hire counsel. Risks: high legal costs, slow process, family rupture, and uncertain recovery. Hire an elder law attorney or probate attorney. You have fiduciary claims, complex finances, suspected exploitation, or if you need guardianship, an attorney can evaluate evidence, local statutes, and alternatives like mediation or probate petitions. Okay, guys, that's your A for today. I will be back on later with B for y'all. For now, Gator Wellness. Take care, folks.